Welcome. Today's video covers public recording, Terry stops, and Miranda warnings, and comes from Honor Your Oath Civil Rights Investigations channel. A link to the original video can be found in the description below. On August 5, 2016, YouTuber Honor Your Oath Civil Rights Investigations conducted a First Amendment audit on a public sidewalk in Volusia County, Florida. Shortly thereafter, two law enforcement officers pulled to the side of the road, approached him, and questioned him about his conduct.
Just taking photographs?
Take photographs?
Yeah.
We'll take photographs of?
Whatever I can see for public. I'm just gathering information about just investigative journalist gathering content for a story, that's all.
Okay.
Here's my hands. Got nothing in my hands, alright?
Why are we taking pictures of the plant?
Why not?
Why not?
Yeah.
Raise a little bit of suspicion.
It's not illegal though, right?
It's not illegal, however, it is suspicious in nature. With it being as, you know, what it is. So, you have a vehicle with you?
I'm not answering any questions. Like I said, I explained to him I'm a journalist gathering content for a story.
You have an ID with you?
And so he's already confirmed I'm not breaking any laws. So.
Well, we're still talking to you. We need to identify who we're talking to.
I can't hear you. I'm sorry.
We're trying to identify who we're talking to, just because there was a suspicious. It was called out that there was a suspicious person walking around taking photographs. The way things are right now, we at least need to identify who we're speaking to, so we can make a notation that you were in the area, who you were, and what you were doing. If you're taking photos, that's fine. But we still need to find out who we're talking to.
Who I am is investigative journalist gathering content for a story.
Okay, I need your name though.
I'm taking photographs.
So that's perfect.
Unless I'm being detained. Am I being detained?
It's an investigation, so right now you are being detained.
I am being detained?
You are being detained until we can figure out who your name is. I'm giving you a chance to give me your name. We're conducting an investigation as to what you're doing. Therefore, I'm asking you for your name.
What reasonable articulable suspicion do you have that a crime is afoot?
You're in an area taking photographs of a power plant.
Is taking photographs of a power plant a misdemeanor or a felony?
What is that? Sorry?
Is it a misdemeanor or a felony to take pictures?
Right now you're failing to identify who you are while being investigated by a law enforcement officer. That's the crime that you're committing at this point.
In response to the auditor's question of what reason the officers have to believe he has broken the law, Deputy Richardson says that, at this point, the auditor's crime is that he is refusing to identify himself. In the case of Brown v. Texas, the U.S. Supreme Court said, "We have recognized that, in some circumstances, an officer may detain a suspect briefly for questioning although he does not have probable cause to believe that the suspect is involved in criminal activity. However, we have required the officers to have a reasonable suspicion, based on objective facts, that the individual is involved in criminal activity." The application of a Texas law to detain an appellant and require him to identify himself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe appellant was engaged or had engaged in criminal conduct. Accordingly, appellant may not be punished for refusing to identify himself, and the conviction is reversed. This case sets a clear precedent that officers may not order a person to identify himself and then detain him for refusing to do so unless the officers have reasonable suspicion that the person is engaged in other illegal conduct. So the crime the auditor is suspected of committing cannot be his failure to identify himself without suspicion of some other offense. In addition, around the 1.5-minute mark, Deputy Bustamante is told by the auditor that Deputy Richardson has confirmed he is not breaking any laws, to which she says they could continue their search for his identification, even if he is subsequently found to not have broken any laws, because there was an investigation. However, considering an investigation into one's identification is only allowed during a lawful detainment and a detainment becomes unlawful once suspicion of illegal activity is dispelled, officers cannot extend the stop for that purpose unless they request identification prior to the original suspicion being dispelled and the person refuses to provide it. But regardless, the officers are also incorrect in their assumption that they had reasonable suspicion to detain the auditor in the first place. In the case of Florida versus JL, a caller reported that a black male in a plaid shirt was illegally carrying a firearm at a bus stop. The Supreme Court ruled that the tip, standing alone, did not constitute reasonable suspicion because reasonable suspicion requires that a tip be reliable in its assertion of illegality, not just in its tendency to identify a determinate person. Here, the only thing the officers had to go off of was a call of a man near a power plant taking pictures on a public sidewalk, which if anything is less of an indicator of illegal activity than the tip in JL, considering filming is not illegal in Florida and there was no report of any potential threat of anything.
What would that be?
Failing to provide identification to a law enforcement officer when you have been asked to do so.
Is that a crime?
It is a crime.
You have
Well-
to provide law enforcement with an identification or your name so that when it's going to ask upon you not doing so.
But you've already confirmed that I'm not doing anything illegal. I'm not violating any
Besides
laws.
failing to identify yourself at this point.
There's no duty. I'm not refusing. Don't get me wrong. But there's no duty to identify if I'm not suspected of a crime.
Okay.
Is that right?
We're telling you right now, you're completing an investigation as to what you're doing and what you're photographing.
I've already told you that I'm an investigative
Correct.
journalist gathering content for
However,
story.
Along with that, we need to identify, we're asking you that we need to identify who you are so we can make a notation that you were in the area and you're going to be in the area taking photographs. Okay,
Well-
failing to provide law enforcement officer with a form of identification after you have been asked to do so is a crime.
Okay, so I'm not refusing. What will happen if I don't give you guys identification? Because I don't think it's in your business who I am. You've already confirmed that I'm not committing a crime. What I'm doing is perfectly lawful. I'm standing on a public sidewalk. Not only is it, just let me finish. Not only is it perfectly lawful, it's constitutionally protected activity.
Okay.
Did you guys take an oath to uphold and defend the Constitution?
Okay. I'm not asking you whether or not you are going to be taking photographs on the side of the road. That's not what we've already clarified that.
Right.
However, what we're discussing now is the fact that you're failing to provide law enforcement with an actual identification or your name so that you can make a notation that we may contact you.
This is a First Amendment protected right. You guys are detaining me unlawfully. And now you're forcing me to give up my identification, which is unlawful.
In the case of Williamson versus F.H. Mills, the 11th Circuit ruled that an officer likely had reasonable suspicion to detain, but not probable cause to arrest, an individual who was taking photographs of undercover law enforcement officers at a public event, but only because he knew of the death threats against a fellow officer and that criminal organizations prize photographs of undercover officers because of the help the photos give them in weeding out law enforcement infiltration. Consequently, photographs of the officer could be useful in carrying out any death threats. And since the officer knew of the recent convictions of the makers of another death threat against her, he could reasonably have believed that the current death threats were real. However, there are no such facts present here. The only issue is that the auditor is taking pictures and filming in public, and the court in that case made clear that taking photographs at a public event is, on its face, an innocent act. Additionally, in the 2021 case of Khoury versus Miami-Dade County School Board, the U.S. Court of Appeals for the 11th Circuit ruled that it was clearly established in 2015, meaning any reasonable officer would have known in 2015 and thus in 2016 as well, that an individual had a First Amendment right to film the officers, vehicles, and the surrounding area on a public sidewalk just outside of a school. Consequently, the detainment and arrest of Khoury for doing so violated the First and Fourth Amendments. With these cases in mind, it is very possible that a court would consider the officer's decision to detain the auditor to be plainly incompetent police work.
I'm going to give you guys a chance not to do that. I'm not refusing to do it, but I'm going to give you guys a chance not to unlawfully detain me.
We need to know who we're speaking to.
Are you going to give us your identification or not?
Am I going to be arrested or not if I don't give it to
It
you?
just depends. Why are you refusing to give it?
Because it's none of your business who I am. It's my personal information.
I'm law enforcement officer. I have the right to find out who I am.
What is y'all's names and badge numbers? Do you have a supervisor?
I do. You want me to come over? Because I'll be more than glad
Please
to come
call your supervisor and we'll take it from there, okay? Now I want to make it clear I don't consent to being detained. I like to be free to go and go about my business.
I understand that.
Are you recording as well?
Yes, everything's
Excellent,
recorded.
excellent.
He's also recording his live streaming on Facebook right now.
That's perfect.
You guys both confirmed that you're recording, so I'm going to be doing,
Everything's being recorded.
I will be doing a public records request to obtain those videos.
Right now you're telling me journalism. That's perfectly fine, but I have no way of proving that unless you provide me some kind of identification that states that you are. And if you do, then that's fine. You're good to go. We'll go on our own way. Well, it's the loitering and prowling is what we were looking at because you're in an area at a time that's not common for normal people to be in photographing.
Deputy Bustamante says that the auditor may be in violation of Florida's loitering and prowling statute, which is codified as Statute 856.021, because it is unusual for people to film in that area at that time. Not only does this statement disregard the fact that taking pictures in broad daylight on a public sidewalk designed for the exercise of expressive conduct is not at all uncommon and First Amendment audits have been increasingly popular for a long time, it disregards an entire element of the offense, which is that the person's actions must portray a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. While it is true that Section 2 of this statute says officers may use an individual's refusal to identify himself as a factor to consider in determining if he poses a threat, the Florida Supreme Court said in the 1985 case of Watts v. State, the failure to identify is not an element of the crime here. Moreover, a person's identification or refusal to identify is merely a circumstance to consider in deciding whether the public safety is threatened. Other factors listed include a person's flight from police and effort to conceal himself or an object, both of which point in the auditor's favor. Individuals also must be given an opportunity to explain their presence and conduct, which he did, and an arrest is only warranted if an officer does not believe the person has a legitimate purpose in the area, and the officers themselves have said that the auditor is not breaking any laws by filming. This statute clearly does not apply, and it appears evident that the officers are attempting to find excuses to justify their actions.
Like I expressed to Deputy Richardson, I do not consent to being detained. I would like to be free to go as soon as possible.
As soon as we can find out who you are and we can possibly identify who you are, you'll be more than welcome to go.
Alright, sir, I'm going to advise you of your constitutional rights, okay? You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions, and to have him listen during any question. If you cannot afford a lawyer, one will be appointed to you. Before any question, if you wish, if you decide to answer questions without a lawyer present, you'll still have the right to stop answering at any time. You'll also have the right to stop answering at any time until you talk to a lawyer.
Deputy Richardson's actions here demonstrate a clear and common misunderstanding of one of the most basic parts of criminal law. In the case of Miranda versus Arizona, the U.S. Supreme Court ruled that, in order to introduce a person's statements against him in court, officers must give the person what is known as Miranda warnings, which includes a statement that the person has a right to remain silent, that anything he says can and will be used against him in court, that he has the right to have an attorney present during questioning, and that an attorney may be appointed for him if he cannot afford one. The court made clear that this only applies during custodial interrogation, which is where an officer says or asks something that is reasonably likely to elicit an incriminating response while the person is in police custody. As stated by the Florida Supreme Court in the case of State versus Connor, in order for a court to conclude that a suspect was in custody, it must be evident that, under the totality of the circumstances, a reasonable person in the suspect's position would feel a restraint of his or her freedom of movement, fairly characterized, so that the suspect would not feel free to leave or to terminate the encounter with police. The U.S. Supreme Court clarified in Illinois versus Perkins that, it is Miranda's premise that the danger of coercion results from the interaction of custody and official interrogation, whereby the suspect may feel compelled to speak. Consequently, as the court said in Berkemer versus McCarty, the comparatively non-threatening character of detentions of this sort explains the absence of any suggestion in our opinions that Terry stops are subject to the dictates of Miranda. Therefore, as the court explained in the case of California versus Beheler, for purposes of receiving Miranda protection, the ultimate inquiry is simply whether there is a formal arrest, or restraint on freedom of movement of the degree associated with a formal arrest, which is often referred to as a de facto arrest. Courts have found custody to exist in cases where an individual was involuntarily brought to the police station, a person was forced to sit in a chair isolated from anyone else, and a 13-year-old was removed from his classroom and brought to another room, where he was sat down with several school and law enforcement officials around him. No such compulsion exists here, and it is clear that the detainment is simply an ordinary Terry stop requiring only reasonable suspicion. Therefore, the officer has no reason to Mirandize the auditor. It should be noted that most citizens incorrectly equate Miranda warnings as a precursor to an arrest, and officers have been known to recite them to elicit compliance from people who fear they may be arrested. However, considering the officers have been incorrect about everything else in this video, it's likely this officer is just uninformed of the actual rule announced in the Miranda case.
Send you to those rights advice to explain them to you.
Hi, I'm Sergeant Ford. How are you, sir?
Sergeant Ford.
Nice to meet you.
What's your name, sir?
My name is Jeff. I'm an investigative journalist. I'm just taking photographs. They've already advised me that that is not illegal.
No, it's not. And no, Jeff, I don't think you're a terrorist. Oh, fine, but if that's all you do is taking pictures.
Okay. Am I free to go?
Outside, Jeff.
I know it is. Am I free to go?
What's that?
Am I free to go?
Yeah.
Okay.
Yeah. What's that?
We don't know who you are.
Well, you don't want to give us your last name or anything like that, Jeff?
I'd rather not if I'm not doing anything illegal.
You wouldn't even give us your first name.
Well, you said it's Jeff. I mean, if it's Jeff, Jeffrey, I don't know.
Okay.
But no, you're not doing anything illegal.
Okay. So I'm free to go?
Yeah.
Okay. I'm just going to head this way if I could just...
Oh, go ahead, Jeff.
Okay. Thank you, guys. Have a good day.
Jeff, you know that, were you recording our conversation between the two of us?
I am, yes, sir.
Okay, well, you didn't tell me you were recording that conversation, did you?
No, sir.
Okay, that's illegal under the Florida statute. You realize that?
Actually, it is not.
Yeah, it's under Security Communications Act is what it is.
Not when it comes to public officials.
No, I think you're wrong, buddy.
Florida's Security of Communications Act, which is codified as Statute 934.03, prohibits, among other things, electronically intercepting an oral communication. According to Statute 934.02, Oral communication is defined as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. In the 1985 case of State v. Inciarrano, the Florida Supreme Court explained, this expectation of privacy does not contemplate merely a subjective expectation on the part of the person making the uttered oral communication but rather contemplates a reasonable expectation of privacy. A reasonable expectation of privacy under a given set of circumstances depends upon one's actual subjective expectation of privacy as well as whether society is prepared to recognize this expectation as reasonable. The fact that the sergeant is on a public sidewalk making a clear conversation about a matter of public concern that could be heard by anyone in the area and was done in front of 2 other officers with body cameras which were also recording the conversation and can be released to any members of the public who request them, obviously quashes whatever theoretical reason he may have had for thinking their conversation would remain private, and therefore this statute would clearly not apply.
Okay? But you need to tell me you're recording me. If I'm talking to you, say, hey, I'm recording this conversation, and I'll be fine with that, because you've told me you're recording me, okay?
Overall, all the officers involved in this encounter get an F. All of them were misinformed about every aspect of the law and they baselessly accused the auditor of various possible crimes while illegally detaining him for 30 minutes. It is astounding how 2 deputies and a sergeant could be so ignorant of even basic aspects of the law, and it's safe to say that this is probably not the group of officers you would want to work in law enforcement. The auditor gets an A. He was cordial, clearly exercised his rights, and attempted to educate the officers about the law. He also remained on the public sidewalk and did not attempt to escalate the encounter like some auditors tend to do, though he would do well to revisit Florida's Security of Communications Act, as his blanket statement that it does not apply to public officials is not entirely correct.